Have you heard that there's a risk in getting somebody on board in your business and then accidentally treating them as a contractor when in fact the law considers them to be an employee? It's a massive risk. Holy cow. The fine is $51,000 per mistake that you make. So the case I was just reading before, the employer made 6 mistakes. They were fined by Fair Work Australia, 51,000 times 6. So it's really important to get this one right. There is an easy way to work out whether somebody in your business should be considered to be an employee or a contractor. Now, it's not just what you want it or what you think it is. If you want them to be a contractor and they want to be a contractor, that is not the legal test. The law decides. There's a whole set of rules. The law decides whether they're a contractor or an employee. So you don't get a choice and they don't get a choice. So the easy way to work it out is that the ATO has got an online, they call it an online calculator. Now, you have to be careful because they don't guarantee the results 100%, but at least it gives you a starting point. You don't have to come to a lawyer like me. I'm a lawyer. My name is Cathryn Warburton. My clients call me the Legal Lioness. You don't have to spend money. Go on to the ATO website, do a Google search, ATO, employee versus contractor calculator. If you search for that, the link will come up and there's a whole bunch of questions and you just answer the questions, and at the end, if the result says either you have to pay PAYG or you have to pay superannuation for that worker, that means the law has decided that that person is an employee. You cannot treat them as a contractor. You have got to pay them the proper rates. In Australia, we have to pay under what's called a modern award. Each different industry has a different type of modern award, so you have to make sure you're paying under the correct modern award. You have to pay the correct entitlements. This could include superannuation, PAYG, leave pay, sick pay. There will be a minimum wage rate, an hourly rate, depending on their experience, how long they've been with you for. There are also, it varies from industry to industry and from modern award to modern award. So for example, some awards say that you have to pay them for at least a 3-hour period. It doesn't matter how long they work for. If they come into the office for 30 minutes and done 30 minutes worth of work, you have to pay them for that at least 3-hour shift. And it differs. Every industry is different. Some awards allow different working hours. So if they start before the hours determined by the award, so if the award says they can start from 7 o'clock and they started at 6 o'clock in the morning, then you have to pay a penalty rate. So it's essential. You have to know, do they fall under the definition of an employee? And if they do, what the requirements are. And you can find out from Fair Work Australia. Now, Fair Work Australia has been set up to help employees and make sure that they get the correct entitlements. But as the employer, you can ring them up as well, and they will tell you what the requirements are in your particular situation. So it's worth trying to avoid that $51,000 fine per mistake that you make. Ring up Fair Work Australia, make sure that you get it right, and make sure that if you've got somebody on as a contractor, that they actually are not an employee in disguise. I call them an accidental employee. Somebody who you thought was a contractor that turned out to be an employee.